People's emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion.
Before a single ruling is made, this hearing immediately raises the stakes. What begins as an emergency bond motion quickly becomes a debate over one of the most important questions any court must answer. Can the alleged victim and the community remain safe while the defendant stays out of custody? The prosecution is already arguing that the original bond conditions weren't enough, and that instantly changes the atmosphere in the courtroom. Remember, bond hearings aren't about deciding guilt or innocence. They're about evaluating risk. And when allegations involve threats, weapons, and ongoing intimidation, the discussion becomes far more serious. Judge Simpson is now balancing two competing responsibilities, protecting public safety while also preserving the defendant's rights before trial. As this hearing unfolds, pay attention to how both sides present the same situation in completely different ways. One side sees a serious danger. The other sees unproven allegations. That conflict will shape everything that follows.
It was arraigned on May 1st and was given a personal cognizance bond, and this was against people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim's defendant argument, he called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. And she also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions, in this one case, to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops, I don't give a fuck, I'll murder your ass the day I get out." And that was before this case. So I have concerns, given that she has finally reached out to police about this defendant's behavior, what could happen to her, given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
That single response from Judge Simpson shifts the entire direction of the hearing. Up until now, the prosecution has painted a troubling picture filled with allegations and concerns. Now it's the defense's turn to respond. Notice the strategy here. Rather than arguing every accusation point by point, the defense focuses on compliance. That's often a strong approach during bond proceedings. They highlight the fact that the defendant quickly obtained the GPS monitor, is working with social services, pursuing housing assistance, and attending scheduled appointments. The message is clear. Regardless of the allegations, look at the actions being taken right now. It's a direct contrast to the prosecution's focus on potential danger. At this point, the judge is weighing two competing narratives and deciding which factors matter most when determining whether additional restrictions are necessary.
I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of who drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the courts. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any.
This may be one of the defense's strongest arguments in the entire hearing. The phrase change in circumstances carries significant legal weight here. Courts generally need a meaningful reason to revisit decisions that were made only a short time earlier. The defense is essentially arguing that the court already reviewed the facts, already imposed conditions, and that nothing new has happened to justify stricter restrictions. Meanwhile, the prosecution continues emphasizing the severity of the alleged threats and the victim's fear. That's what makes this hearing so compelling. It's not simply a disagreement about facts. It's a disagreement about risk. Should the court respond more aggressively because of the allegations, or should it trust that the current GPS monitoring is sufficient? Here's the question. If a defendant follows every bond condition perfectly, but the accusations involve repeated death threats, which factor should carry more weight? That's exactly the challenge facing Judge Simpson.
On a GPS tether, the court can know where he is at all times, and I believe that this bond is sufficient to protect community safety.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where is the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
It's by the Miller and Maple Park and Red, sir.
Well, just so that we're clear, this isn't by the Maple Miller Park and Ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
But I'm holding out until I can get help, sir.
Yes, so she is part of the Pathway Housing Program. I do have a letter from that social worker here if you'd like that, the honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark arrive at the court today.
The only address I have is the South Line address. Is that a correct statement?
Pay close attention to the direction of Judge Simpson's questions here. He's not asking random background questions. He's building a picture of relationships, living arrangements, and potential contact points. Judges often do this when evaluating safety concerns. The court wants to understand how the defendant knows the alleged victim, where family members live, whether a child is involved, and how likely future interactions might be. Every answer helps establish the practical realities of the situation. What's especially important is how often the discussion returns to family connections. Shared children, past relationships, and close personal ties can make no-contact orders far more complicated to enforce. These aren't strangers who can simply avoid each other forever. The judge appears focused on understanding the day-to-day reality before deciding whether additional protections are necessary. The deeper these questions go, the more it feels like the court is preparing to modify the existing conditions rather than leave them unchanged.
How do the defendant and the alleged victim in this case, how do they know each other?
I believe they have been in an on and off relationship since January 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child who resides with mom, is that?
With her mother,
Her mother.
the victim's mother.
Which the magistrate did order no contact with the victim's mother as well on the day of the event.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in Southline as well, so I believe so.
How old's the child?
Born in 2019.
Oh, 6. 6. The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
At this stage, the hearing becomes surprisingly personal. Instead of focusing entirely on the allegations, Judge Simpson begins examining the defendant's living situation and financial circumstances. Those details matter more than many people realize. Bond conditions only work if they can realistically be followed and enforced. The court wants to know where the defendant is staying, how monitoring costs are being paid, whether the living arrangements are stable, and whether ongoing compliance is possible. The answers reveal challenges involving homelessness, temporary housing, and limited financial resources. But from the court's perspective, another issue is equally important: reliability. Can this individual consistently follow the rules? Can authorities locate him when necessary? Will the monitoring system remain effective? Those questions directly affect the court's assessment of public safety. It's also noteworthy that Judge Simpson is gathering much of this information personally, which often signals that he wants a complete factual record before making a final decision.
Are you the only one out there at that site? Let me see counsel in chambers. Court standing. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the DPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay.
I understand.
And then, and I don't want it put on the record, But I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim, and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone as all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this time, I guess theoretically the motion is granted. The exclusion zone will be extended to all of South Lyon, and I will add the child's name there. Anything further?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
All right. Thank you.
And here comes the ruling. Judge Simpson ultimately lands somewhere between the positions argued by both sides. He declines to increase the monetary bond, which means the defendant avoids being taken into custody. However, he also decides not to leave the conditions exactly as they were. Instead, he expands the exclusion zone and adds a no-contact restriction involving the minor child. That's a significant outcome because it shows the court recognized the concerns raised by the prosecution while still allowing the defendant to remain on bond. Throughout this hearing, the issue was never guilt or innocence. It was risk management before trial. The prosecution argued that stronger protections were necessary. The defense argued that the defendant was complying and should not face harsher restrictions. Judge Simpson's ruling reflects elements of both positions. The GPS monitor remains in place, incarceration is avoided, but additional safeguards are added. In the end, the court chose increased supervision rather than a tougher bond. If this case surprised you, let us know your thoughts in the comments, and don't forget to like and subscribe for more courtroom breakdowns.